Last week, Vice President Jagdeep Dhankar continued raising questions over the judiciary's alleged overreach. This time, he criticized the Supreme Court for using the doctrine of basic structure to strike down the constitutional amendment that introduced the National Judicial Appointments Commission Act. In fact, in December last year as well, Dhankar had called the striking down of the NJAC a severe compromise of parliamentary sovereignty and disregard of the mandate of the people. And this criticism isn't actually new. In fact, now Law Minister Kiren Rijiju has written to CJI DY Chandrachud suggesting that the Supreme Court Collegium should include government representatives as well. But what is the NJAC judgment and why did the Supreme Court strike down the NJAC? And more importantly, how are judges actually appointed through the collegium system? I'll answer all of these questions for you in this episode of KYC or Know Your Constitution. Now, before I bring you to NJAC, let us briefly first understand how judges are actually appointed currently at present, because this whole controversy is actually connected to judicial appointments. You must have heard about the collegium system, the word collegium being thrown around and the system being spoken about every now and then, and how judges are appointed in India. Basically, the judiciary appoints judges in India. Now, Supreme Court Collegium is basically a group of Supreme Court judges sitting together to recommend appointment of judges to the Supreme Court and various high courts. Now, this collegium comprises the Chief Justice of India and 4 senior-most judges of the Supreme Court when they have to consider candidates for appointments to the Supreme Court. These judges, like I said, officially form a part of the collegium. If the collegium is considering elevating a High Court judge to the Supreme Court, then the Chief Justice also consults senior Supreme Court judges from that particular High Court to get to know more about this High Court judge who they're thinking of elevating. The opinion of all the members of the collegium as well as opinions from other judges is then sent to the government. The Law Ministry is then to put the recommendations to the Prime Minister, who will advise the President in the matter of appointment. Now, in case of High Court judges, that is appointment of judges to the High Court, the proposal for appointment is initiated by the Chief Justice of that particular High Court. The High Court Collegium comprises the Chief Justice of the High Court along with 2 senior-most judges of the High Court. This collegium sends its recommendations regarding appointment of judges to the Chief Minister of the state, the Governor of the state, the Centre, as well as the Supreme Court Collegium. The Law Ministry then considers the recommendations and forwards all the material it has along with the candidates' background checks to the Supreme Court. The Supreme Court Collegium can clear names of these appointments to the High Courts only after it receives proposals from the government following the candidates' background checks. The Supreme Court Collegium for High Court judges appointments has the Chief Justice along with 2 senior-most judges of the Supreme Court. Once the Supreme Court Collegium also approves the names for appointment to the High Courts, the files are sent back to the Law Ministry for their notification. So this is a very elaborate procedure to appoint judges to the High Courts and the Supreme Court. But you might be surprised to know that this isn't a system that the Constitution directly spoke about. The text of the Constitution does not use the word collegium, but this entire practice actually came up and evolved through Supreme Court judgments. And these cases basically arose out of the struggle between the executive and the judiciary on exactly who of the two should have the final say, the upper hand when it comes to appointment of judges. This struggle, of course, continues even today. Now, this collegium system evolved through 3 major judgments. You can see the names of these judgments on your screens right now. In 2014, the government then finally made an attempt to overhaul this entire system for appointment of judges. Enter National Judicial Appointments Commission or NJAC. In August 2014, the Parliament passed the Constitution 99th Amendment Act 2014 along with the National Judicial Appointments Commission Act 2014. This new body was supposed to be an independent commission established for recommending judges to the Supreme Court and the High Courts throughout the country, essentially to replace the collegium system. There was an amendment to add Article 124A to the Constitution to establish an NJAC. Basically, this commission was to comprise of the Chief Justice of India as the chairperson. The other members included 2 senior-most judges of the Supreme Court, the Law and Justice Minister, 2 eminent people to be selected by the committee comprising of the Chief Justice, Prime Minister and Leader of Opposition. So the NJAC also sort of brought in government representation and participation in this whole appointment process for judges. The Act said that the NJAC shall not recommend a person for appointment if any two members of its NJAC, the committee, do not agree to such recommendation. So this was a sort of a veto power. The NJAC, in a sense, was largely seen as another attempt by the government to sort of gain primacy or upper hand in judicial appointments through the composition of the NJAC, as well as the procedure that was laid out for judicial appointments, which would have basically erased the collegium system. And then it was declared unconstitutional by a 5-judge bench of the Supreme Court in October 2015 with a 4:1 majority. Primarily, the court ruled that the NJAC was unconstitutional because it violated the basic structure of the Constitution. Now, let me just explain to you briefly what basic structure doctrine is as well, because Dhankar's attack on this entire NJAC also involves an attack on the basic structure doctrine. In simple words, the Supreme Court has ruled that while the Constitution can be amended, there are some elements of the Constitution that cannot be changed. That is, they are unalterable. Essentially, the court said that laws or amendments that are found to damage or destroy the basic features of the Constitution or its most essential features cannot be brought in. So it's sort of a test that is applied to constitutional amendments to ensure the amendment does not, or a law does not dilute the fundamentals of the Constitution itself. There's of course no set list of what constitutes the basic structure, but over the years, for example, federalism, secularism, equality and rule of law have all been held to be a part of the basic structure of the Constitution. Now, in the NJAC judgment, what was the basic structure? The majority judges basically held that judicial appointments, being an integral facet of judicial independence, are part of the basic structure. It also ruled that judicial primacy, that is, the judiciary having an upper hand in judicial appointments, is also a part of the basic structure of the Constitution. And so it held that the NJAC, that is the Act and the constitutional amendment, they both violate the basic structure by doing away with judicial primacy through its veto provisions that I just told you about. So, for example, the court felt that since the Act also provided that 2 of the 6 members of the NJAC could veto any appointment, it was possible for the 2 eminent people or one of them in collusion with the minister to stall an appointment favored by the Chief Justice and the 2 other judges. This was not only bad law, but also undermined the independence of the judiciary. That is what the court felt. But there was a surprise dissenting opinion in this verdict by Justice J. Chelameshwar, who lashed out at the secrecy and lack of transparency in how judges to the highest constitutional courts are appointed. He even refused to participate in collegium meetings unless there was some record of what transpired in them. Now, just to bring you back to the present, Vice President Dhankar's remarks reflect the criticism that is often made against the basic structure doctrine as well as the collegium system of appointments of judges. Both of these are criticized because they're not really found in the original text of the Constitution itself. Over the years, there have been many arguments from both sides. For example, the basic structure doctrine is criticized because it finds, like I mentioned, no mention anywhere in the Constitution. Some also believe that the doctrine gives powers to the judiciary to impose its philosophy over a democratically elected government. Others, of course, believe that the doctrine strengthens democracy by limiting the power of a majoritarian government to undermine the Constitution's central ideals. So it sort of keeps the Constitution's central ideals intact and safe from being altered. But the debate is, of course, still unsettled. This is Apurva Mandhani for The Print. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.